Hello everyone, my name is IGNASIA DEWI. I am from Group 6. Today, my group and I will talk about commercial law. Background of the emerging commercial law. Before the existence of commercial law, the relationship between traders was regulated based on the freedom of contract and the decision of a commercial court or jurisprudence. This is what traders make of customary law. The French King Louis IV ordered to systemize the terms of trade until Provision on Trade in General, or Ordonnance du Commerce, in 1673. 2. Provision concerning trade by sea, or Ordonnance de la Marina, in 1681. 3. Code of Commerce Law, or Code de Commerce, which was made post-revolutionary in 1789. Move into the next part, which is commercial duties. A. Carrying or moving goods from places that are excess, surplus to places that are less or minus. B. Moving goods from producers to consumer. C. Hoarding and storing these goods in an excessive period until it threatens the danger of shortage. Let's move into understanding commercial law. According Ahmad Ihsan, commercial law is the law that regulates trade matters, namely matters arising from human behavior in trafficking. According to R. Sukardono, commercial law is civil law in general, which regulates the issue of agreements and engagements regulated in Book 3 BW. In other words, commercial law is a set of regulations that regulate a person with other people in company activities, which are mainly contained in the codification of the KUH Perdata and KUHD. Understanding commercial law according to Fokerma Andrae. Commercial law is the entire legal rule regarding companies in trading traffic, to the extent that it is regulated in the KUHD and several additional laws. According to HMN Purwosucipto, commercial law is a law of engagement that arises specifically from the company's field. It can be concluded that commercial law is a series of norms that arise specifically in the business world or company activities.
Hello, my name is TARISSA HIDAYATI. I'm from Group 6.
Relationship between the KUHD and the KUH Perdata. If you look closely at Article 1 of the KUHD, which contains the Civil Code, to what extent in this code of commercial law, there are no specific deviations. It also applies to matters touched upon in us. It is concluded that the Civil Code is a general provision in regulating business relations, and the KUHD is a special provision that regulates the business world. For more details, it can be seen from Article 15 of the KUHD, which contains all companies mentioned in this chapter are controlled by the agreement of the parties concerned by this book, KUHD, and by civil law. The principle that applies is lex specialis derogat lex generalis. Company terms. The terms traders and traders' actions are in Article 2 to 5 of the KUHD before the revocation in 1938. According to ST 1938-276, dated July 17, 1938, due to the following reasons. The definition of goods is not only movable goods, but also immovable goods as trade objects. The purpose of selling includes acts of commerce or trade. If disputes arise between traders and non-traders, it is difficult to determine what laws apply. The term company is first encountered in Article 6 of the KUHD. Every person who runs a company is required to keep books. The problem that arises is that there is no understanding in the KUHD from the company. Memory von Tocqueville Amphitys said that all actions that are carried out continuously, openly, in a certain position, and for profit. Mullengrave said, all actions that are carried out continuously, acting outside earning income, trading goods, handing over goods, entering into trade agreements. Pollack said, the company has two characteristics, namely calculating profit and loss and keeping track of books. The formula is based on Article 1.b of Law No. 3, 1982 concerning the compulsory registration of companies. Every form of business that runs a business that is permanent, continuous, and domiciled in the territory of the Republic of Indonesia to obtain profit and/or profit.
I'm YOSANTO PRANOTO from Group 6.
Form of business entity. Individual companies, owned by individuals, limited or simple management, capital is not too big, and the survival of the business depends on the owner of the company. Cooperative. This type of business entity consists of people or cooperative legal entities by promoting its activities based on the cooperative principle, as well as people's economic movement based on the principle of kinship. BUMN is a type of business entity where all or part of the capital is owned by the government. There are three forms of BUMN: Perjan, public corporation, and Persero. BUMS, type of business entity that is established and capitalized by a person or a group of people. BUMS can be divided into firma, CFI, PT, and foundation. Firm is a business entity founded by two or more, where each member is fully responsible for the company. The firm's capital comes from the founding members. Profits are distributed to members in proportion to the deed at the time of establishment. CFI. It is a partnership company founded on mutual trust. In CV, there are several allies who are fully responsible for other allies. Then there is one who is the donor, and the limited partner's responsibility is only limited to a certain amount of capital. PT. It is a corporate legal entity that is great in demand by entrepreneurs because in this law it has advantages over others, such as the extent of business entities that can be owned freely in the movement of business leaders and their responsibility is limited to paid up capital. Foundation. Formed based on the prevailing laws and regulations. Foundations are formed by separating the personal wealth of the founders for non-profit, religious, and social and humanitarian purposes. Established by notarial deed, has no members and does not have anyone, but has a committee or organs for its functioning.
Thank you for
Thank you for watching.
Okay, that's all from us. Thank you for watching. Bye!